Okay, and we're live. I'm Sean Caranna. I'm the executive director of Florida Carry. My co-executive director, Rich Nascak, will be here a little. He's running a bit late, but should be on shortly. Uh, Going from my left, we have Eric Friday, who's our lead counsel. Eric, say hi, introduce yourself.
Hello.
We have the Tack Daddy joining us tonight. I think he had to step away from his computer for just a second. And everybody's favorite guy from Georgia, the Stone Guy.
Hey, thank you. Stone Guy 223.
All right, so what we're going to be talking about, and this is going to become a bi-weekly show. We're going to have these live chats that we do every other week on Mondays, 9 p.m. Eastern, to keep really mostly targeted for ratings, but we will get into a lot of the federal issues as well, facing gun rights and self-defense rights, but particularly as they relate to Florida and to the members of Florida Carry. For those of you that don't know, Florida Carry is Florida's largest independent Second Amendment rights organization, and we go beyond just what you might think of as Second Amendment. We go into a lot of the self-defense aspects and a lot of the related fields that are necessary in order to secure your right to bear arms. But so kind of jumping right into it, recently we filed a lawsuit against the University of Florida. That case was brought after we won a case against the University of North Florida that required that students and visitors to the campus be allowed to lawfully store their firearms in their car. The universities were prohibiting that, and in fact were saying that they were going to criminally prosecute people for doing so. Our plaintiff in that case, Allie Linez, came to us, and she had a problem. She is a single mother who was going to school at University of North Florida and had to make over a half-hour commute every day getting to and from class. So we filed a lawsuit on her behalf and won. Subsequent to that, the University of Florida didn't quite do a very good job of coming into compliance with the law. And Eric, I'll let you fill in the rest of the blanks on that case.
Well, we had a couple of issues. Number one was the University of Florida wanted to continue regulating firearms despite the fact that the legislature has told them to quit regulating firearms. They wanted to continue regulating them. They felt like a footnote to their policy would be sufficient, even though the policy still stood just as it had since well before we filed the UNF case. They also made an attempt or continued to prohibit firearms in campus-owned housing. Now, generally when we speak of campus-owned housing, the immediate thing that comes to mind is dormitories. But in the University of Florida's case, it's not just limited to dormitories. This includes single-family housing units that are on campus where there are people like graduate students with families whose spouses live with them. Those spouses have no affiliation with the university. They work in the community. They travel the roads of the community. They are not under the protection of campus police most of their day, yet they are denied their right to have a gun in their home by the university policies. There are also things like off-campus housing that the university owns apartment buildings. And just because that university owns that apartment building sitting in between two other apartment buildings, that university apartment building does not allow students to have firearms in their home, but in either building on either side of them, students have a right to protect themselves. So what we were saying is you do not lose either your constitutional right to bear arms in your home just because of who owns the property you live in, nor do you lose, or as well, the legislature has specifically protected the right in Florida to have a firearm in your home. And this is particularly interesting because we've had several housing cases across the country dealing with people who live in public housing. And in every one of those cases, either the housing authority has backed down or the courts have ruled that people have a right to have a firearm in their home, whether that home is a private home or whether that home is owned by the government and leased out to somebody under an entitlement program.
That I was just about to ask something along those same lines. Eric, is the university, is that a state funded facility in any way, or is it completely private? Or
This is the University of Florida Gators.
oh, okay. So
Yeah, absolutely escape school. In Florida, we have I think 40 some odd state colleges and 9 universities. Is
okay.
that correct?
Well, because the reason I bring this up is because this has been an issue. I mean, not only in my area, but other areas that I've heard of, and it seems like the qualifying question is always, well, is it a state funded property or is it a private property? And the reason they ask that is because it would seem that if it was obviously if it's a private property, they would have a little more latitude on being able to institute restrictions. But if it's a state funded or state owned school, how could that, like the I don't know, the head of that school or the like the I don't know how to phrase it, the government of that school, how would they be able to supersede the law of the state that the school is provided through? Does that make sense?
Sure. Well, in this case, one of the issues is we have in Florida a statute that bans possession on school property, very similar to Georgia. And in fact, you may be aware that there was a case concerning a hotel that is actually off campus in Athens at UGA,
Right.
Georgia at Athens, where an individual in the hotel had a firearm with him, not realizing that the university was completely owned the hotel. It was actually charged and convicted of having a gun on school property. Florida has a similar statute, no guns on school property, but there's a clear exception in that law for guns in private vehicles.
Okay.
The additional,
But now, let me ask.
comes in is when the legislature, we've had a right to guns despite the United States Constitution and the rulings in Heller and McDonald, even predating that for several decades. We've had a right to possess a firearm in the home in the state of Florida. The idea of a gun-free school zone only really came about in the early 90s, I believe 1992 in the case of Florida.
Right.
The question is when Florida banned guns on school grounds, did that include the leased premises that the student resides in, or did the right to possess a firearm in the home still apply under state law? What did the legislature mean there?
Right. Well, let me maybe that's an easier way for me to ask this. Okay, since you said they in whatever year it was they passed the legislation or the restriction to make a school-free zone, and I guess that's my big question is how can a school, whether it's whether it's private or public at this point, how can the head of that school or that organization, how can they make a restriction on something on that property if the rest of the state say for instance, if a state was a constitutional carry state, that didn't even require a firearms license for carry. We're just hypothetical here. So it's a constitutional carry state, but yet the state-funded school says you cannot carry guns on our property. How are they allowed to do that if it's a state-funded school and the state says it's okay?
Well, in this case, one of the arguments or disputes in this case is, has the legislature authorized it, or is the school acting in compliance with state statute by banning guns from the entire campus? So in this case, it's not a question of the school is, from the school standpoint, the school's argument is not that we're allowed to ban what the legislature has permitted. They're arguing that the legislature has prohibited possession in dorms and in student housing, even though there's nothing in the law that says that. They argue that the prohibition on possession on school property extends to the private home of the student who resides in a housing unit owned by the university.
Okay, I see. So they're kind of using the law in their favor, and they're hiding behind the law. But in essence, the law is really not clarified. It really doesn't state what they're saying it does.
Well, I'd put a finer point on it. It's a matter of interpretation of the law, of the statutes.
What if they've also gone to the state Department of Agriculture and Licensing and gotten a concealed carry permit and are 21?
Well, there's no exception for concealed carry licensees. The one big difference would be if you are a concealed carry licensee, having your gun in that dorm room is a misdemeanor, not a felony under state law. But that gets into another area that the challenge.
That was my second question: is what is the penalty? So you just cleared that up. If you have that license, it's a misdemeanor.
Right,
if you do get caught, or if you do get called out and found guilty of having a weapon on you.
Right. But that raises another issue now, because now you've got the question of, okay, you have an individual who's on campus who has a license, therefore the state has said that the penalty is a misdemeanor. Well, guess what? Colleges don't. We have preemption in Florida. Colleges don't dismiss students for misdemeanor convictions. They only dismiss students, as a general rule, for felony convictions. So if you get a DUI off campus, the school doesn't punish you. If you get a DUI driving on campus, the school is limited, generally speaking, to loss of your driving privileges on campus, loss of your parking privileges, and otherwise you don't really generally face any academic punishment. But the legislature's already said what the penalty for possession of a firearm with a concealed carry permit on campus is. It's a misdemeanor. It's a second-degree misdemeanor, which means it's not even I take it back. It may be a first degree, but bottom line is, it generally does not result in jail time.
And real quickly, Eric Coggins joined us. He's Florida Carry's campus policy director, and he's the state director for the Students for Concealed Carry for Florida.
Hey, welcome.
Hey, how's it going? Here.
So anyway, the question then becomes, well, how can a university with preemption in place in the state of Florida, how can a university punish a student beyond that punishment which the legislature has already set forth for the potential for that violation that's alleged?
Right. Then that was my whole thing: is how can any of these state schools or universities supersede the status quo of the state that they're in?
Well, in some states, the schools are given the authority to regulate possession of firearms on campus.
Okay.
First off, the first question is, you know, if you don't have a preemption statute like Florida has and like many other states have, there's nothing that prevents the university from controlling their property, because they're acting. They argue they're acting in that case as a private property owner, which gets back to the private property discussion you mentioned in your initial question. As far as your initial question, the private property question, that's an issue that we expect is going to come forward more and more, because we're starting to see things like apartment leases that prohibit possession in your leased premises of your apartment. And I'm talking now about private apartment complexes. So that's going to eventually become an issue.
Right. Well, most definitely. I mean, where do you draw the line? Yes, it's private property, and I think for the most part we can all get behind, you know, free market and being able to regulate your own private property, but it's kind of like that old saying that your rights end where mine begin.
Yeah, and generally an individual's rights are generally superior and supersede a business owner's rights in most cases. For example, when you choose to open or operate a business in a state, that's a privilege in most states. And part of the privilege of engaging in businesses in most states is that you give up certain rights. You give up the right to discriminate against who comes into your business. You give up the right to deny things like animals coming onto your property if they're service dogs. There's many examples of where the state has said, in these cases, you, the business owner, you, the private property owner, must give up certain rights in order to operate a business in this state. And I don't think guns are any different. I think the right to carry will eventually be recognized, or alternatively, business owners will have to accept more liability when they choose to prohibit firearms on their property. I've lost audio.
No, I can hear you. I think everybody was just soaking in.
Muted. Sean looked like he was talking, but it looks like he's muted.
I had myself on mute. And Rich Nascak, my co-director, has finally been able to join us. I guess he got his computer working.
Well, welcome to you, sir.
What's up, Rich?
How's
What's
it
up,
going?
everybody?
And, well, I guess he doesn't hear us, or...
Jagger.
I guess he's still working on that computer.
Hello.
Hello.
There he is.
Rich.
We got you.
Can you hear us?
1, 2, test.
Yeah.
test.
Can you? We can hear you. Can you hear us?
How weird.
Okay. Well, while Rich works himself out there, we'll try him again in a minute. So, Kevin, you brought up before we started the chat that you wanted to talk about another case that has been getting a lot of media from here in Florida, the so-called Docs v. Glocks case. So, Tack, why don't you cue that one up?
No problem.
Not hearing anything here, folks.
You're breaking up, Tack.
All right, am I here? Can you hear me?
Yeah,
There
we
you
got you now, brother.
All right, sorry about that. Basically, what you have is a federal court upholding a Florida law that limits the doctor's discussion of guns with their patients. Now, the question I had before we get started to keep in mind for you guys that are a little more in the legal world than I am is I also heard there was something having to do with veterans being asked whether or not they had their guns and a certain protocol being followed. This was 6 months ago, maybe a year ago. We were really talking about this quite a bit. So that in the back of the mind, but this comes to the ruling by the 11th Circuit Court of Appeals in Atlanta, and basically the law was known as Docs versus Glocks. It allowed doctors to ask the question of their patients whether or not they owned firearms, and their whole argument was along the lines of, you know, if it's dangerous to them, just like smoking or bad eating habits, we have the right to ask. And again, where that all goes, who knows? But the bottom line is that the privacy of firearm owners has trumped everything, and you do not have to answer those questions if they're asked, and they're not allowed to ask them, it looks like.
Right. Well, and it's important to distinguish between what you're hearing in the media and what the actual truth of the matter is. They keep saying that, oh, well, we're not allowed to talk about guns with our patients. That is absolutely positively false. It is a lie, and it's one that's being pushed forward by the media and the people that are against the law. A doctor could certainly hand you a gun safety pamphlet and talk about guns all they want. What they cannot do is ask you, do you own a gun? They can't ask you, they can't say, I'm not going to treat you because you're a gun owner. They can't say, we're not going to send a home health care nurse to your house because you have guns in your home. And that was, at least for me, when the bill was going through, that was really the most important thing to me personally, because I've had some experience with that with my parents and home hospice refusing to come to the house.
Well,
because my father owned a rifle.
And while we're kind of on that subject, how does that carry over to schools, school systems, and different things like that? Are they
Hold
are the
on,
school?
Before we go there, how does it carry over to like things like insurance and things that really matter when it comes to a doctor asking you that question? Because where is that information going to go if he's actually collecting it in another state? I mean, sorry to interrupt you, and I think the school stuff's important too, but go back to the doctor's office. You're sitting there, and this guy's saying to you, you know, do you have any handguns in the house?
Well, that's what he said. He said that now they are not allowed to ask you that. They can provide you information, but they cannot ask you if you have firearms
I
in the
will
house.
have to find it. I will have to find it, but they actually handed out to my daughter a thing talking about being safe around other kids and stuff like that, and talking about if you see a gun in another kid's house. And the picture of the gun was bizarre. So I have to find that and bring that up at another time. But so back to the doctors. Why are they asking this question? I think is the greater question. Why were they? Why were they? I guess.
Let me tell you the reason they were. The American Academy of Pediatrics hold hands with and carry water for the Brady campaign and have been for many years. For whatever reason, the American Academy of Pediatrics, very similar to the American Bar Association and a lot of other so-called professional groups, are strong proponents of gun control. And they have for years advocated this idea that gun violence and guns are a public health hazard or a public health crisis, and have used that to justify talking to their members and encouraging their members to advocate for gun control or safe storage laws or safe storage actions by their patients.
Thank you for the detailed explanation. I appreciate it.
Yeah, if you look at the court case on that, the 11th Circuit made a point to talk about some of the examples of what was going on, and so, some of the most egregious things were they were telling patients that if you don't answer our questions about guns, you're not going to get Medicare or Medicaid. You'll be disqualified from the program, which was a lie. And we've unfortunately seen a lot of doctors say things like this, but but they've never been true. And so there was a thing going through the gun community of people looking into, oh, my doctor told me I can't get Medicare benefits if I don't answer their questions about guns. And it wasn't because Medicare was actually doing it. It was because there were doctors telling their patients this in order to get them to fill out their form.
So now is that a state thing that individual state has ruled that the doctors can't do that, or is this a federal thing that extends to all?
It's a state statute, and what the court said was doctors' relationship with their patients are highly regulated, and because we have tons of regulations on what doctors can and cannot do when they're dealing with their patients, so it's completely a valid exercise of the state to regulate that type of conduct that doctors engage in with the patient.
And the doctor's challenge was on First Amendment grounds. That's how it ended up in federal court. The doctors were claiming that Florida's law that prohibited them from asking certain questions impaired their First Amendment rights to free speech in dealing with their patients. And that's why it ended up in a federal court to determine whether the state statute violated their federal protections under the U.S. Constitution.
Yeah, it seems like that'd be I don't know how, I'm not sure of the exact wording in their Hippocratic Oath, but it seems like they would be against trying to eliminate people from care based on such extenuating circumstances as owning a firearm in the home.
Apparently we had some physicians whose thoughts on guns outweighed their Hippocratic Oath. Of course, I think we've seen that in a few professionals refusing to honor their oaths, haven't we?
Oh yeah, no kidding. Now back to it kind of plays into the whole thing I was talking about with the schools. Do you guys know of any situation where are the schools or personnel from the school allowed to contact your children about firearms? Are they allowed to ask them anything about firearms in a school setting that would relate to your home setting?
We have seen some problems with the Department of Children and Families doing just that. Eric, I'm not sure how much you can talk about that case.
I can talk about the generalities of it. I don't want to get into specifics of who the individual was, but we did have an individual contacted us. This has been, I think, probably a year or more ago. And the Department of Children and Families of Florida has assured us very strongly that they are very much in understanding of what the Second Amendment says and what Florida law is, and that such things should not happen in the future. But we have had at least 2 cases. One I am not as intimately familiar with. The other I am very intimately familiar with. And in that case, a investigator from DCF actually came to the children's school based on a report to DCF that the father owned firearms and kept firearms in the home. That was the extent of the report. Not that he left them laying out, not that the children were using them improperly, or not that the children had access to them, or anything other than shooting with their dad, but just the fact that he had them resulted in a DCF investigator speaking to the children without the parents' knowledge or permission, because DCF does that regularly anyway and has the authority to do so for reported abuse cases or endangerment of children cases. And then DCF came to his home to speak with him and made contact with him and started asking questions about his ownership of firearms, which he refused to answer.
Yeah, that's the kind of thing that's that's where hopefully there'll be some type of case brought forth, because honestly it's going to take something like that going horribly wrong for it to be brought up and someone to actually pursue it in the court system. Because just like the doctor things, I think that should be a federal mandate across all medical boards, like part of their whatever they do when they pass the medical, whatever, that should be like a federally mandated thing across the board, not just an individual state.
Well, I don't, given our federal Congress, I don't have a whole lot of hope for getting any kind of such regulation passed at the federal level. I think we're going to have to do it state by state, where there's organizations like Florida Carry or organizations in other states going to have to do it on a case-by-case, state-by-state basis, where they start making it clear that we're not going to tolerate this out of our healthcare professionals. We're not going to tolerate it out of our insurance companies, which we just had here in Florida this year. We're just not going to allow discrimination against gun owners simply because they exercise their right to keep and bear arms.
Amen on that. And I think that's a good thing, like what you guys are doing, because Eric, and you could speak probably volumes to this as an attorney, the fact that you use case law as a benchmark or a reference in maybe other states, where you could reference the fact that, look, Florida did this, it's passed in Florida. Wouldn't an attorney in another state reference you guys?
When you're dealing with a state law like Florida's recent law that prohibits insurance companies from discriminating against gun owners, it has absolutely no impact, applicability, or precedential value in another state that does not have that law. They certainly can lobby for a similar law in another state, saying, hey, look what Florida did. Florida's fixed this. Now we need to fix this too. But as far as going to a judge in a court case and saying, hey, there's a law in Florida that says insurance companies can't discriminate, well, that doesn't do you any good in Georgia unless you have the same law in Georgia, because things like regulating insurance companies are a matter of state law.
Oh, okay. Well, that's good to know, because I guess I've been watching too much TV. Where you always hear the attorneys or the lawyers that reference a case, like so-and-so versus so-and-so, and that kind of sets the bar for what they're arguing at the time.
And that works when you're dealing with things like, Georgia has said, the Georgia Supreme Court has made this ruling about the Second Amendment. Well, that it's not binding, but it can be exported to Florida and argued to the Florida court as, This is what the Georgia Supreme Court's done with this issue, and Florida should do something similar. But that's usually based on a U.S. constitutional argument or a similarly worded statute. For example, other states have looked at what Florida has done with Stand Your Ground and have either accepted what Florida's done to determine how to rule on their own Stand Your Ground statutes, or to say Florida got it wrong and do something different with their Stand Your Ground, how they apply their Stand Your Ground law. So there's times when, yes, you can use precedent from another state as highly persuasive, saying, hey, a Supreme Court in another state's already looked at this. We ought to do the same since our Supreme Court hasn't ruled yet. We ought to go the same way, or this is why they got it wrong. So, yes, that can be used, but in a case like where you're dealing with a state statute and the other state doesn't have a similar statute, then it doesn't work.
Okay. All right. Cool. Thanks.
All right. So, and real quick, and we didn't get into this. We have two cases right now. We alluded earlier to the preemption law here in Florida. We have two cases that we filed recently, one in cooperation with the Second Amendment Foundation. The other one, Florida Carry did completely on her own. Eric and his co-counsel in this case, in the Tallahassee case, is Leslie McKinney, who works with us on a lot of our stuff. She's also working on the UF case with us. And in South Florida, we have another set of attorneys who filed a case the same day as we filed against the city of Tallahassee on preemption grounds, also against Broward County. Tallahassee, a few days ago, answered our complaint, denied everything, said, no, we're not breaking the law. Nothing that we didn't expect. But then they turn around and countersued us, claiming that because they are locally elected officials, they are, no matter what rights they may violate, they are immune from lawsuit. They're claiming sovereign immunity. So that puts us into kind of an interesting situation where if the state's going to defend the statute for those types of applications, the Attorney General might need to get involved in this case. And Eric, I don't know if you've even had time since you came back from vacation, getting tan and apparently growing a bit of a beard, to even read through any of that.
I haven't even looked at the response from Tallahassee yet.
Oh, you're in for a treat. They brought forth everything that the petitions seek. They claim, just like the doctors did, that we're messing with their First Amendment right to free speech by keeping them from voting in illegal gun control. They can
speak whatever they want to. They just can't take actions that are specifically prohibited by law. I mean,
they are literally claiming that when we do something that's not within our authority and it violates the law, we have sovereign immunity.
Well, they just need to pass a law that says, let them pass a law that goes back to the only people of certain colors considered a lunch counter and see how that works for them. I don't expect it to work any better than it will in the gun context either.
And same situation, and not quite the same. They haven't countersued in Broward County. They've come back and said, well, we're not enforcing the law, so leave us alone, but we're not repealing it either. Which gets into this weird area where we see these cities and counties right now trying to leave laws on the books that they know are invalid, but they're doing it just to try and confuse the public and have the public believe that something's against the law.
Or like passive-aggressive, huh?
Right.
Kind of a passive-aggressive approach.
Yeah, I think, Eric, correct me if I'm wrong, that's what they call chilling the right?
That's one of the terms. It's an attempt to prohibit an action without actually violating the right. but just passing laws that discourage people from exercising their rights.
And luckily for us, here in Florida, those laws are all null and void, with very few exceptions. And we'll see where those cases go. But it's been real active in the on the legal front. On the legislative, we're right now the legislature is in special session dealing with redistricting, but nothing really self-defense or weapons or firearms related going on there right now. What we do have going on, though, is some proposed rulemaking by Florida's Fish and Wildlife Commission to allow for the use of suppressors, silencers, while hunting. And it's something that we've known has been coming for a while. We've spoken to people over the past couple of years about this type of rulemaking, and it's just coming up to a head. Florida Carry got with attorney David Goldman a few months ago, and he usually sells his NFA gun trust for $200 or $300. It's an excellent product. It's really, if you're going to get a National Firearms Act regulated firearm or suppressor or any other weapon, short barrel shotgun, short barrel rifle, anything like that, getting a gun trust is really the way to do it. And what we're able to do with him, because he likes us, he likes Florida Carry and wants to support what we're doing, he gave us a really good deal on being able to sell his top-rated NFA trust to our members. So we've really just passed along that value to our members, and we have a deal that we do right now. If you go to floridacarry.org, it is $100 to become an executive member of Florida Carry and get the NFA trust.
That's a steal.
So but I'd kind of like to get the opinion of the panel. What do you guys think about the idea of being able to use a suppressor for hunting?
Well, I'll speak to that real quick, and then I'll yield to everybody else. But Georgia, we just passed that law in Georgia. Georgia HB 60, I think it was an HB 60, or it may have been 61. But either way, you can now legally hunt with a suppressor in Georgia. I think it's a fantastic idea. We've spoken to that before, and I think in some areas of Europe it's actually required. So, I don't know why it's taken us this long to pass the legislation in the states.
For a long time in Europe, you could walk into your average hardware store and walk out with a suppressor made for whatever gun you had. They for a long time had a lot of restrictions on guns, but the people who can lawfully own them, accessories like what they call moderators there, you're exactly right. It's considered to be the polite way to shoot. Here in the U.S., I guess too many people saw James Bond movies.
Exactly. I think everybody should have the right, and that really goes for hearing protection at home. You think everybody thinks about, I should have the right to have a shotgun in my house, or this, that, and the other. And I mean, you're talking about damaging or ruining your or anybody in the close vicinity's ears for quite some time. If you have to discharge the weapon.
Yeah, I mean, that's exactly right. I mean, if you've ever done any kind of stalking through the woods, obviously having foam earplugs in and regular earmuffs on and going through the woods, it's really just not safe because you're, muffling all the sounds around you. And then when you do take that shot, if you don't have the hearing protection in, one good shot can do permanent hearing damage. So I think this is a great safety-related regulation. We certainly hope to see it pass here in the coming weeks.
And Sean, I'm assuming NRA is supporting that change?
That's my understanding, yes.
Yeah, I can't imagine really any opposition. I guess the biggest thing is that there is kind of a negative connotation associated with the word silencer, or you know what I mean. It's you're right, you're exactly right. It's Hollywood that's portrayed. The fact of someone being able to screw on a device and magically, kill someone without being heard or seen or.
And it's more accurate.
Right.
Well, and, we had a commenter the other day that was talking about this, and they said something about, well, oh, that's horrible. It's not fair to the animals. You might be able to kill more feral hogs that way because they won't all run immediately because it was just a completely silenced shot.
Oh, we might be able to kill more of an invasive species? How dare we?
Exactly. And this idea that, if you're going to fire a rifle with a so-called silencer and it's going to be truly silent and not make the animals run away, obviously someone who's never been around an actual suppressed rifle.
Yeah, that's a good point. I mean, obviously you're gonna, basically all it's suppressing for a rifle, a rifle that's gonna break the sound barrier, is the immediate sound and percussion right there at the right there at the breech, or once that projectile leaves and goes down range, and it breaks that sound barrier, you're gonna hear the crack of that round, punching through the air. So I think that's a lot of people don't think that it silences that it's just completely silent. So.
Well, is there even any such thing as a subsonic hunting ammunition?
Well, the 300 Blackout, it can reach subsonic. Right there on the cusp. What's typical sound barrier is 1100, 1050.
It's about 700. It's about 700 to 750 miles per hour. So I don't know what that equates to in feet per second.
Yeah, I want to say it's like 1050. I think it's like 1050 feet per second, somewhere in that area. And I know people will be like, well, it depends on your altitude and your barometric pressure and all that jazz, but somewhere in that 1,050 feet per second. So if you get a projectile, and that's why 45s are so notorious for being silenced, because a 45 caliber pistol round is typically going to stay in that 850 to 900 feet per second, which is well below the sound barrier. But a rifle, just about any rifle round, short of that 300 Blackout, is going to be a hyper velocity. You're talking 3,000, 3,200 feet per second. You're definitely going to hear the crack of that round going through the air.
Right, and even the 300 Blackout, not all 300 Blackout ammo is subsonic.
Correct.
They do have subsonic loads. But even if you take one of those subsonic loads and put it in a long enough barrel, it's still going to go supersonic on you.
Absolutely, but I do agree with the when you preface the question with the whole trust thing. I think trust are an absolute must for NFA items, not only for your protection, but the protection of anybody in your household that may inconsequentially possess that item. And the example I've given a couple times now is the fact that if you were to purchase a silencer, let's say, and you just driving home with it from the gun store, and you pull in the driveway and you're unloading, and then your wife decides she needs to run to the grocery store and hops in your car real quick, takes off, and now she's in possession of this silencer, and if she's caught, that's a 10-year federal sentence. I mean, it's ridiculous to think that they make these laws, or they make it in such a way that makes people criminals inadvertently, you know. So with a trust, you can list anybody that may come in contact with that item on the trust, and they would be, I don't know the legal term for it, but they would be covered, I guess.
They become a trustee or a party on that trust that allows them to be in possession of everything that trust owns, including those NFA firearms, and that's really important part of the protections of that. And if you remember, this was I guess a year or so ago, there was a guy who loaned his AR-15 to a friend, and this friend goes to the range and experiences a couple of slam fires. So he pulls the trigger and 2 rounds come out, or 3 rounds come out in a couple of instances. And just happened that someone contacted law enforcement about this person and reported that he had a full auto machine gun. The FBI or the ATF rather took the firearm, gave it to the lab. They couldn't recreate it until they used it with specially made up ammo that they got with especially soft primers. If you're familiar with the AR-15, the firing pin free floats in the bolt carrier. Well, in his case, he had, I believe, an aftermarket firing pin that was a little heavier than standard. So when it free floats and when it would chamber the next round, there was enough inertia there to set off an especially soft primer. If you take your standard AR-15, load it up with the regular ammo, and drop the bolt, eject the round on the one you just dropped, take a look at the back of your primer, you're going to find a small dimple, which is fine. That's why they use hard primers in ammo that's supposed to go into the AR-15, because we know that it's got that drop. But they basically induced a malfunction on this AR so that they could put this person in jail under the NFA.
What state was that in?
I don't recall off the top of my head. It was somewhere out west. I can.
Oh no! The only reason I asked is because I was just gonna follow up with, in a situation like that, is that something that your organization, Florida Carry, is that something that you guys would jump on the bandwagon and get behind this guy?
Certainly. If it was one of our members, absolutely. If it was someone here in Florida that was just really doing nothing wrong, then that's something that we get involved with, because it's just a ridiculous prosecution. The problem is that the courts upheld it. They said that the ATF has determined that this is what constitutes a machine gun. And we were able to make it act like a machine gun, therefore it's a machine gun. And the person, and the thing is, it was the person that loaned his friend the AR-15 is the one that got in trouble, not the guy that was out there pulling the trigger.
Oh, not the guy that actually
because he illegally transferred a machine gun.
Right, the guy that was experiencing the problem wasn't prosecuted. The guy who loaned him the gun, who possibly had never experienced the problem even, was the one who was held responsible?
Right.
Wow.
Yeah, that's definitely, and I think, and I don't know if you guys advocate this or not, but I think that's a perfect example of why you should have some type of alternate or alternative insurance, whether it be something like through the NRA, or I think there's a couple other companies you guys are probably more familiar with than me.
There's no way to insure. There's no way to insure against criminal charges.
Well, I'm talking about the insurance that would allow you to get a lawyer and fight the fight. Sure. You know, because that could financially cripple someone if they have to go through even a self-defense situation. Have to go through the legal battle.
Right. And there's actually a write-up on the FloridaCarry.org page. There actually is, under the education link, a write-up that I did that looks at or gives some suggestions of questions you need to ask and what you need to look for when looking at a plan for what's colloquially called self-defense insurance.
Right. Okay.
Yeah, and none of these are anything that we're selling. This is just purely for people's information out there. That may change in the future. We may actually start offering that as a member benefit. Just depends on how much demand we see for it later.
Well, Eric, let me ask you, since obviously you're in the industry, with your experience and exposure to different things, is that something you would advocate for or recommend that someone have some type of self-defense insurance?
Yes, if you happen to be an individual who has, if you're a multimillionaire, it's probably not necessary to buy such a thing. If you are indigent and you're going to receive a public defender, regardless of some of the justified criticisms of some public defenders, the homicide teams tend to be excellent attorneys who are extremely experienced. It is probably a waste of money of very limited resources you don't have to buy such a plan. But if you're of any type of middle income individual, odds are you are not going to be able to afford the $15,000 to $25,000 initial minimum retainer and the anywhere from $50,000 to $100,000 minimum that it would take to defend a capital type murder case. So yeah, $150, $200 a year, whatever it is, depending on what plan you get, is money well spent if you ever need it.
Well, and not just a capital case. I mean, this would include, generally they bring second-degree murder charges or manslaughter charges for what is justifiable self-defense.
And then the number's closer to 25 to 50, not 50 to 100 most of the time. It depends on what you're charged with as to whether or not you're looking at the 25 to 50 range or 50 to 100 range. But gosh, Zimmerman case alone, that was hundreds of thousands of dollars just in expert fees and transcripts and things, not even counting the attorney's fees.
Yeah, that's a good example of something that could easily happen to any of us. That's a.
So getting into some of that, one of the things that Florida has that's supposed to protect people that are forced to act in self-defense is Florida's so-called stand your ground law. An important part of that law is not so much the stand your ground aspect, but the immunity from prosecution, in fact, an immunity from arrest when someone acts in self-defense. You are supposed to have an immunity. There is a proceeding that you usually go through if you're going to claim the immunity, and that's a pretrial evidentiary hearing where the judge decides if you're going to have immunity or not. Currently, when you go to trial, you've all heard the term, you're innocent until proven guilty. Unfortunately, at these immunity trials, that's not the case. You are guilty until you prove yourself innocent, and that's to say that the burden of proof lies with you. You walk in with the assumption to this immunity hearing that you don't have the immunity, you probably did something wrong here. Eric's working a very important case right now for a guy named Jared Bretherick. And Eric can key up a little bit of that. And But Florida Carry and National Rifle Association both filed briefs in the case, amicus briefs. Erica, can you talk about that case a little bit?
Sure. Jared Bretherick was a 22-year-old young man. Both of his parents are disabled veterans. He was riding in the passenger back seat with his parents and his 15-year-old sister when one of our local convicted felons, who I am led to believe is currently a guest of Sheriff Grady Judd down in Polk County for, again, battering somebody. Mr. Dunning, the felon, tried to run this family off the road, and when they honked the horn, that was unacceptable to him. So he pulled over in the middle of 3 lanes of Orlando traffic and slammed on the brakes right in front of the Bretherick family, causing them to stop right behind him. 2 lanes of flowing traffic on either side. They could not escape around the car. They were also very concerned he had a gun. Mr. Dunning actually gets out of his car, comes towards the family. When he sees the family's gun, all 3 adults in the car have concealed carry permits. When he sees the family's gun that Dad's holding up, he goes and gets back in his heavily tinted windows Cadillac Escalade truck, rolls up his windows, pulls his mirrors in, and backs up closer to the Brethericks. At that point, the Brethericks had no idea what he was doing. Was he loading a gun, getting a gun, what was going on? Dad handed the gun to his son, Jared, because Jared was the only one that was able to easily walk because of his parents' disabilities. Jared got out and eventually took up a position beside his dad's driver's side door, behind the door, with his gun aimed at Mr. Dunning's vehicle in front of him in case Mr. Dunning decided to get out of his car again. The family waited like this from the time after Mr. Dunning had already come back towards their car and then went back to his own vehicle. At that point, the family called 911. It took over 10 minutes for the police to show up, and when they did, they arrested Jared Bretherick, concealed carry holder, for aggravated assault with a firearm of Derek Dunning, the previously convicted of aggravated battery felon who likes to beat up pregnant girlfriends, road rage cases, and people that owe him money, and decided to believe Mr. Dunning's story over Mr. Bretherick's story, and therefore the state attorney is charged and is prosecuting Mr. Bretherick with ag assault with a firearm. You're muted again, Sean.
Dang it. And beyond that, though, and we think in large part because of where that burden of proof lies in these cases, this whole idea of being guilty until proven innocent on the immunity hearing, he was denied immunity. It went to the Court of Appeals that also, because of a previous Supreme Court case, had to deny him immunity, saying that we're bound by previous Supreme Court decision on where this burden of proof is. And now that's in front of the Florida Supreme Court. Like I said, Eric wrote an excellent brief to the Supreme Court trying to get the burden of proof for the immunity shifted back to the state where it should be, just like it is at trial. Florida Carry wrote an amicus brief. The NRA has. And just today, the Attorney General filed their brief in opposition to changing the standard from guilty until proven innocent back to innocent until proven guilty. We're all still looking at that brief to see exactly what it stands for, but it's certainly troubling that we have the state that has so much zeal for prosecution that they're not willing to make sure that people that have to defend themselves are protected from these types of prosecution.
I know we're about out of time. I wanted to give a quick rundown on some of the people who submitted amicus curiae briefs, and I'm assuming each of these that I'm fixing to read were in support of or in opposition to the Docs versus Glocks bill, in opposition to preventing doctors from using their power and their position of authority to try and advocate for gun control. Among those were the Broward County Medical Association, the Florida Public Health Association, the University of Miami School of Law, Early Childhood Initiative Foundation, American Academy of Pediatrics, American Academy of Child and Adolescent Psychiatry, American Academy of Family Physicians, American Academy of Orthopedic Surgeons, American College of Surgeons, American College of Preventive Medicine, several other doctors' groups, as well as the Alachua County Medical Society, the American Public Health Association, American Association of Suicidology, that was a new one for me, Suicide Awareness, Voices of Education, and of course the Law Center to Prevent Gun Violence. And I also see here that the ACLU Foundation of Florida filed an amicus. I'm not sure which side they filed it on. Something tells me it's another example of the ACLU not being able to count to 10 without skipping a few numbers, though.
All right. Well, with that, we have run out of time here. We'll be back again. It's every other Monday, starting at 9 Eastern. In the meantime, please come check us out at floridacarry.org. Join the organization, protect your right to bear arms, and Stone Guy had to drop off a few minutes ago to start his chat. And I'm probably going to head over there. I'm not sure if any of our panelists have any time to go and talk on his a little bit more informal chat. But if you want to look at that, go to gunchannels.com, hit the little more button and look for the Stone Guy chat. You can watch that show. Always fun over there. And I want to thank everybody that came out and played with us tonight, and y'all have a good night.
Thanks, man. See you next time.